Hello, everyone. Today we will be talking about the criminal law process, which is what will happen if you were to be arrested. So, the criminal law process has 8 steps, and there are little parts to every step that all interact with the Constitution. The first step is probable cause. So, in order to be arrested, the police have to have enough evidence to arrest you. Probable cause can be something like the police saw something, or maybe they smelled something, um, and they arrested you for the thing that you did. Probable cause could also be um, evidence, like say that someone were to be murdered and the police found a murder weapon with your DNA on it. Well, that would be probable cause to arrest you. Or let's say you were speeding and or ran a red light and the police had a photo of you in an intersection as the light was red. That would be probable cause to make an arrest, which is why red light cameras are constitutional. The second part is the arrest itself. The court has to issue an arrest warrant if the police officer does not see you commit a crime. When you are being arrested, you have to be read your Miranda rights. If you remember Miranda versus Arizona, he was not read his Miranda rights, and that was a violation of the Constitution, and that's how Miranda rights got their name. If you recall, Miranda rights are you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford one, one will be appointed to you. Those are your Miranda rights. Step three is booking. That is where, after you're arrested, you'll be taken to whatever jail it may be or whatever police station it may be and charged with a crime. Or you actually won't be charged with a crime yet, but you'll be fingerprinted and photographed and allowed to call your lawyer or a lawyer. And if you can't afford a lawyer will be appointed to you. You may be issued bail, which is a sum of money that you can pay in order to be released from jail. And when you return to court, you receive that bail money back. Now, a lot of people confuse bail with a bail bondsman. A bail bondsman will only charge you between 10 and 20% of whatever your bail is. So if your bail is $1,000, then you may have to come up with $100 to $200 to give to the bail bondsman, and he will front you the rest of the money. And then when you return to court, he takes the whole $1,000 and you don't get your money back. That is how bail bonding works. The fourth step is the preliminary hearing. That is where the suspect is formally informed of their charges. So this is where they would become the defendant. This is where they would be charged. As part of the writ of habeas corpus, which says that you must be informed of your charges or must be informed of what you're accused of doing. Not necessarily what you did, but what you are accused of doing. Step 5 is the indictment. So the grand jury, remember the grand jury does not actually show up in court, but the grand jury decides if there is enough evidence to go to trial. And remember, there's only a grand jury on the federal level, not a state level. If the grand jury decides that there is enough evidence to go forth with the trial, then the person will be indicted, which means that they will formally be charged with a crime. Side note, only federal level uses grand jury. I feel like I just said that. Step 6 is the arraignment, and that is where the defendant issues a plea. If the defendant issues a guilty plea, they skip the trial and go straight to sentencing. A lot of people will issue a guilty plea if they know they did it and they can get a plea bargain, which we will talk about in just a second. Not guilty, you go to trial and you try and fight to be released. You try and fight to be found not guilty, and that is also called acquitted. A plea bargain is when a defendant pleads guilty to a lesser offense and receives a lesser punishment. So let's say I know they got me red-handed committing a crime, and they offer me a lesser punishment. Let's say I'm accused of murdering someone and I didn't actually do it, but I knew about it and I was there. Well, maybe they give me a plea bargain to give me, say, accessory to murder, and they give me 15 years in prison instead of life in prison, and all I have to do is testify against the actual murder. That is a example of a plea bargain. Step 7 is the trial. In the trial, you have a petite jury, which hears the case and reaches a verdict. They can either acquit, which means being found not guilty, or they can convict the accused, and that means they would be found guilty. There are 12 jurors of your peers, and they are supposed to be impartial, which means they don't know you. They have no feelings towards you. They're not prejudiced towards something about you. So, like, you wouldn't want, let's say there was a man going on trial. You wouldn't want 12 women who are all feminists and do not like men. That would be prejudiced. Or let's say back in the day, you would have an African American going on trial. You wouldn't want 12 white men who were racist to be that person's jury. Yeah. So acquittal means found not guilty, and convicted means found guilty. All right. So what you really need to know about this little side note right here is the adversarial nature of the court. So the adversarial nature of the court means that the whole truth may not come out. Both sides are trying to win. They are going to argue, and they are going to leave out the parts of the story that don't fit with their narrative. So they're not gonna say something that makes their client look either guilty, or the prosecution's not going to say something that makes the person look not guilty. They will only use evidence that makes the person look either guilty or not guilty, depending on what side it is. They're both trying to win, so they're going to leave parts of the truth out. And the last step is sentencing. So while the jury finds the accused guilty or not guilty, the judge decides the punishment, and the punishment is set due to the North Carolina Penal Code or the Federal Penal Code. A penal code is a set of is a set of criminal laws, and it outlines crimes and punishment. So, for example, it's kind of like a menu. Like when you go to McDonald's, it'll be like cheeseburger, $1. In the penal code, it'll be like murder, life in prison. Like there is a set price for each crime. But there are two different types of sentences. You have indeterminate sentences, which gives you a maximum and a minimum sentence. And there's a mandatory sentence, which is a set punishment. So, example, in North Carolina, the mandatory sentence for murder is life in prison. But then you have indeterminate sentences, like for armed robbery, it might be 5 to 10 years in prison. So it just depends on the crime to the sentence. There's indeterminate, there is mandatory. Remember, in America, you are innocent until proven guilty, and you must be given a chance to defend yourself under the Sixth Amendment. This is just a little way to remember the steps. So probable cause, arrest, booking, preliminary hearing, indictment, arraignment, trial, and sentencing go along with police arrest bad people in a terrible society. That's just a little acronym to help you remember, kind of like Let's Eat Jolly Ranchers and Sip Root Beer. So there you go. All right, guys, that is all for today. I hope to see you all soon.